There are times when individuals and entities are put to the test, faced by difficult challenges that require thoughtful and considered decisions. Their choice going forward may be either a path that is safe and socially acceptable, or one fraught with personal, professional, and possibly physical danger. At stake in such contests can often be the measure of one's character and integrity, and in extreme cases, one's legacy. Difficult decisions are presented when words or actions that are morally fair and right are not considered by society to be popular or in favor. Such defining situations force to the surface exposure of the true nature of a person and/or organization. Recently, 2006 Duke Lacrosse accuser victim Crystal Mangum, through her appellate process, put a test of judicial integrity before the North Carolina Court of Appeals. The day of reckoning was May 8, 2019, when the North Carolina Court of Appeals heard in conference Crystal Mangum's appeal of a Durham Superior Court's adverse August 15, 2018 ruling in her malicious prosecution civil complaint. A three-member appellate panel consisting of Judges Phil Berger Jr., Chris Dillon, and Valerie Zachary, all Republicans, were to rule on Ms. Mangum's appeal and a civil complaint arising from a November 22, 2013 jury verdict. Throughout her post-Duke Lacrosse legal jousts, whether acting pro se or under professional representation, Mangum had failed to prevail in her actions, petitions, or motions when adjudicated by the court. Mangum's sole legal victory coming from a jury which found her not guilty of a 2-count larceny of shows inaction charge. Although moral and legal issues weighed heavily in favor of Mangum's appeal for her lower civil court 2018 ruling to be reversed and remanded, she was up against an established history of unfavorable court decisions. The test for the North Carolina Court of Appeals was straightforward: to keep with Mangum tradition and rule for a desired outcome averse to her, or make a determination based on facts, fairness, and merits of the case. The three-judge panel's ruling was filed on August 6, 2019. Judicial integrity test results of their ruling and opinion in Mangum's seminal case follows. Ms. Mangum, due in large measure to suppressive, selective, and slanted coverage by the mainstream media, has been and continues to be a societal pariah, ostracized and denigrated by the masses for pursuing criminal sexual assault charges against 3 Duke Lacrosse players at a March 13, 2006 beer-guzzling, stripper-oogling party for which the host team was renowned. An African-American single mother and NC Central University student at the time, this incident occurred a decade prior to the Me Too movement's appearance, the 3 accused perpetrators being white and hailing from families of wealth, influence, and privilege. Taking over the case in January 2007, The North Carolina Attorney General's Office conducted its own investigation into the case, one in which a March 2007 pivotal 6-hour interview with Ms. Mangum at the SBI Raleigh headquarters was not recorded nor transcribed. On April 11, 2007, then Attorney General Roy Cooper dropped the investigation into the case and unprecedentedly declared the 3 Duke student athletes to be innocent. Immediately thereafter were calls for Crystal Mangum to be prosecuted for filing a false police report, though she staunchly maintained that her accusations were truthful. However, based on unsubstantiated statements by Roy Cooper, Ms. Mangum was labeled a false accuser, and she was targeted by the state and media for payback. Crystal Mangum suffered the consequences that deter reporting by the vast majority of females victimized by sexual harassment and assault from males in positions of power. Those being 1. Not being believed, and 2. Retaliation. The former, promoted by media dubbing her as a false accuser, and the latter being a trumped-up murder charge in the accidental death of her boyfriend Reginald Day 5 years later. In the wee morning hours of Sunday, April 3, 2011, Crystal Mangum was in a fight for her life against her drunken alcoholic boyfriend Reginald Day, in a jealous rage because of attention she had just given to a police officer with whom she had been previously acquainted. During this incident, Miss Mangum sought refuge behind a locked bathroom door, which Mr. Day readily penetrated by using his body to knock the door frame from its jamb. Dragging her into the bedroom by her hair, Day was atop her and strangling her with his hands when Miss Mangum found a steak knife within reach and used it to poke her assailant once in his left side. The act effected the desired result as he jumped up cursing, thereby allowing her to get to her feet, grab her purse, which contained 2 cashier's checks he had given her days prior, and flee the apartment of horrors. Durham police arrested Mangum hours later and charged her with assault with intent to kill, while Day was taken to Duke University Hospital's emergency department by ambulance with a non-life-threatening stab wound. Following an expedited and thorough workup, Day underwent an emergency operation for treatment of a laceration to his colon and minor lesions to his spleen. His post-operative prognosis was for a complete recovery. The following morning of Monday, April 4, 2011, Durham Police Officer Marianne, lead investigator on the case, interviewed Day from his hospital bed, and per her own police record, he admitted that he gave both of the cashier's checks to Crystal Mangum. The checks dated March 25, 2011 and April 1, 2011. Of the 2 medical conditions with which Day presented on hospital admission, the acute stab wound and chronic alcoholism with acute intoxication, the former was successfully attended to, whereas the latter was not. On his 3rd post-operative day of Wednesday, April 6, 2011, Mr. Day lapsed into delirium tremens heralded by severe agitation. This required his transfer to the surgical intensive care unit. There, while treating his condition, he was erroneously intubated in his esophagus instead of trachea. Catastrophic malpractice that invariably results in death if not recognized immediately and removed. Despite indications of its misplacement, the intubation tube was left in place, which precipitated Day's progression to cardiac arrest. The endotracheal tube was replaced simultaneously with the institution of cardiopulmonary resuscitation, and following 20 minutes of CPR, Day's heart was effectively pumping spontaneously, but he was brain dead and in a comatose state. On Wednesday, April 13, 2011, following a week of observation without neurologic improvement, Reginald Day's family gave authorization for his elective removal from life support, after which he died. The following morning of April 14, 2011, then North Carolina Deputy Chief Medical Examiner Dr. Clay Nichols, with Officer Bond in attendance, performed an autopsy on Mr. Day. The next Monday, April 18, 2011, a grand jury was convened with a presentation by the Durham District Attorney's Office which featured a single witness, Officer Marianne Bond. Based upon Bond's testimony, the 12-member grand jury handed up 2 indictments. One indictment was for first-degree murder, and the second was a 2-count larceny of chose in action indictment, 1 count for each cashier's check Mangum was alleged to have stolen from Day. Larceny of chose in action, a rarely prosecuted offense, is an automatic Class H felony. Being a felony can justify elevating a murder charge to first degree through the felony murder rule. And conviction of first-degree murder is punishable with a mandatory life sentence without the possibility of parole, the most desired outcome of the prosecutors, state, and media. With full knowledge that the larceny charge lacked probable cause because Reginald Day had given both cashier's checks to her, Crystal Mangum wanted to have that charge dismissed. Her appointed attorney, Woody Van, and a second attorney recommended to her took no pretrial action towards this goal. In late 2011, Mangum reached out to her non-attorney friend and advocate, Dr. Sidney Harr, seeking his assistance. She was frustrated that the only motions filed on her behalf had sought reduction of her bail. In mid-2012, after receiving prosecution discovery from Mangum, Harr drafted and typed a motion to dismiss the larceny charge on behalf of Mangum in a pro se manner. The court ignored this motion. Then, Harr helped Mangum to manually file handwritten pro se motions to dismiss the larceny of chosen action charge on November 30th, 2012 and December 6th, 2012. The criminal divisions of the Durham Superior Court took no action on either of these motions. Mangum's subsequent attorneys, Scott Holmes and Daniel Meyer, did not file a motion to dismiss the charge during the pretrial phase. By commencement of Mangum's trial on November 12, 2013, she faced 2 charges, first-degree murder and larceny of chosen action. Durham prosecutors concentrated solely on the murder charge, not even mentioning the larceny charge in its opening statement. Neither would it mention it in its closing argument. Following presentation of prosecution's case on November 19, 2013, defense attorney Meyer made motions to the court to have both charges dismissed. Trial Judge Paul Ridgway heard only the motion to dismiss the larceny of chose in action charge. Citing State v. Bauer, Meyer noted that to constitute larceny, there must be a wrongful taking and carrying away with felonious intent. The Durham prosecutors were aware from Officer Bond's April 4, 2011 report that Day admitted to giving both checks to Mangum. Without citation, Prosecutor Charlene Coggins Franks reasoned that the element of larceny was met once Day requested the return of the cashier's checks he had given to Mangum and her non-compliance, the prosecutor's premise being false and unsubstantiated. In ruling against the defense motion, Judge Ridgway cited State v. Tilley, a case involving more than one defendant and in which property was physically and unlawfully taken and carried away. In other words, it was not even relevant to Mangum's motion. The larceny of chosen action charge, along with that of first-degree murder, would be decided by the jury. The 12-member jury began its deliberation late Thursday afternoon, and by Friday morning of November 22, 2013, following less than 6 hours of consideration, arrived at a verdict on both charges.
Madam Clerk, would you announce the verdict?
Ladies and gentlemen of the jury, you have returned with the following verdicts. State of North Carolina versus Crystal Mangum, file number 11 CRS 2608. We, the 12 members of the jury, unanimously find the defendant to be not guilty of larceny chosen action, $400 cashier's check. State of North Carolina versus Crystal Mangum, file number 11 CRS 2609. We, the 12 members of the jury, unanimously find the defendant to be not guilty, larceny chosen in action, $300 cashier's check. State of North Carolina versus Crystal Mangum, file number 11 CRS 2607. We, the 12 members of the jury, unanimously find the defendant to be guilty of second-degree murder, signed November 22nd, 2013, by four-person Ceres Bryant. Is this your verdict? So say you all.
Yes.
Meyer gave the court notice of Mangum's intent to appeal, Judge Ridgway handing down a sentence in the range of 14 to 18 years. Most importantly, the favorable November 22, 2013 verdict on the larceny of chose-in action charge had fulfilled requisites for a malicious prosecution complaint to be brought by Crystal Mangum in civil court.